Hi, I'm Jan McDavid of Hogan and Hartson, and I have the pleasure today of interviewing my dear friend and partner, Sandy Litvack, a former head of the Antitrust Division of the Justice Department, among many other positions. Sandy, how did you get started in antitrust?
Well, Jan, I applied on the Attorney General's Honors Program, and in those days you had to list your desired choices, and you had three. And I was young, I knew nothing about antitrust, and so like all young people, my first choice was the Civil Rights Division, my second choice was the Criminal Division, and my last choice was the Antitrust Division, and that's where I ended up, and started working there straight out of Georgetown Law School, and spent almost 3 years there before I left to go into private practice.
Who was the AAG at the time you were at the division?
Well, Bob Bix was really the acting Assistant Attorney General. He had hired me. He was sort of the first deputy, and a fellow by the name of Victor Hansen, Judge Hansen, was actually the Assistant Attorney General, but I never met him. I did meet Bob and got to know Bob fairly well, but never met the Assistant Attorney General. And the head of my section was a guy named George Raycraft, who went on to have a great career in antitrust as well.
And who were the other AGs during the period you were there?
Your former partner.
Lee Levenger.
Lee Levenger. Couldn't think of
So this was at the end of the Eisenhower and beginning of the Kennedy administration.
Exactly. I came in right at the end of Eisenhower and continued into the Kennedy administration. Indeed, one of my big kicks was getting to go upstairs and meet with Bobby Kennedy, who, when he came in as Attorney General, had a group of us from the Antitrust Division up in his office. And, there were probably 30 of us, I would say. And Bobby Kennedy was a relatively short person because there was a big crowd. He took off his shoes, I remember this so vividly, and stood on his desk and served beer. He served beer in the Justice Department, and my big thrill was meeting Bobby Kennedy. And not to get ahead of the story, but that desk that he stood on became my desk.
Did it? Well, I knew it remained at the Antitrust Division after Bobby was the Attorney General.
And it became my desk.
That's wonderful.
Yeah.
What kinds of cases did you handle during that first stint at the Antitrust Division?
I ended up doing criminal work and grand jury work. In those days, they didn't have the kind of sharp division that they have now. In other words, all the sections handled both criminal and civil matters. And I was in George Raycraft's section, as I said. And we had a grand jury going, actually we had a couple ultimately, involving General Motors, which was my first dealings with General Motors, which I later had many occasions to deal with. But I worked on the grand jury.
And did that case result in an indictment or a trial?
It resulted in an indictment. In those days, Jan, the division, the government, the department, did not have CID power. The Civil Investigative Demand Act didn't exist. So the only way the government had to get information, short of voluntarily, was through criminal process. And the division historically, well before my time, had used the criminal process and grand juries to get information and ultimately to bring civil cases. And in a case that went to the Supreme Court, titled United States versus Procter & Gamble, the Supreme Court held that that was an abuse of power. And the division could not do that any longer. So if they were going to use grand juries, they had to at least intend, not necessarily end up with a criminal case, but had to intend to bring one. And that's sort of the good news and the bad news, because it forced many things into the criminal genre that might not have been but for that. This particular case that I'm talking about ended up with an indictment that probably would have been a civil case if General Motors during the process didn't keep accusing us of abuse of a process, so they almost dared us to indict them, which we did.
And what happened following the indictment?
I think when Lee came in, or subsequently, they brought a companion civil case, the criminal case was dropped, and the civil case was settled. I think that's the way it ended up.
I remember Lee used to have on the wall of his office the president's signed copy of the civil investigative demand legislation, which was no doubt enacted in response to that problem.
It was. I mean, it was done, if I recall correctly, maybe you do, in 1962. So this was the problem that had existed, and everyone recognized that it made no sense for the government not to be able to, proceed civilly with some compulsory process.
So after your 3 years at the division, what was your next stop?
I went to a firm by the name, and you would know it, of Donovan, Leisure, Newton, and Irvine, which was at that time one of, if not the, premier antitrust firm. And a fellow named Jim Withrow, who was a partner there at the time, had approached me and asked me about coming to Donovan and moving to New York. I obviously had lived down here then. And I said yes, and went to Donovan Leisure and spent the next, 20 plus years there before I ended up going back to the Department of Justice.
Well, and the roots of the Donovan firm lay, as I recall, in Wild Bill Donovan.
It did.
And I think that's a story it might be interesting to talk about.
It did. Wild Bill Donovan was the first head of the Antitrust Division. It really wasn't almost a separate division at that time, but he was the first head. And as you know, in the ante room, and it used to be the ante room to my office, they have the pictures of all the assistant attorney generals. And I used to periodically go out there when I held that job and look at General Donovan, and he was in that position, I think 1929, 28, 29, somewhere around there. And he was known as Wild Bill Donovan because of his ventures during World War I, where he was considered a pretty reckless kind of guy. And he left. Hoover had promised him to become Attorney General. You may know this story, but Hoover had promised him to become Attorney General. But because he was Catholic, Hoover would not nominate him. So he left when Hoover left and Roosevelt came in. And he became sort of friendly with Roosevelt because Roosevelt, who was the quintessential politician, played on the fact that Hoover had treated him so badly. And it was that relationship that ultimately led to him becoming the head of OSS, which he was during World War II. Prior to that time, between 29 and 39, he had tried what was then called the Madison Oil case, which was the Saucony vacuum case that went to the Supreme Court.
So he had roots in antitrust, and
Totally.
therefore you went to a firm that specialized in antitrust.
Yep, we did.
And what was it like to be in the private practice of antitrust law in the early 60s?
The private practice of law itself was different, and the private practice in antitrust was different, too. In those days, probably a lot more so than today, and we'll talk about that as we go on, a lot more trials, a lot more dealing with a lot more. Private plaintiffs were just sort of coming into the fore. I mean, this was a process where you started to have more private litigation. Government was fairly active because you're now talking about the Kennedy era into the Johnson era. And the department was fairly active, and Section 7 cases was really the big thing at that time. As later got stated by Potter Stewart, the government won them all. But it was kind of a fascinating time because mergers were taking place at a pace and in a way that hadn't been seen in a long time.
And they were litigated,
Yep.
unlike the way they are today, after they were closed.
Yes, absolutely. Mergers were closed. There was no Hart-Scott-Rodino waiting requirement. There were so-called midnight mergers which were done literally at or about midnight and then announced. And so the government then would have to go in and try to undo the merger. And even, indeed, when Hart-Scott-Rodino was initially passed, the government still would have to go in and try to get a TRO. In other words, there was no automatic stay period as there is now. The government had to go get a TRO. And what that ended up with was a whole bunch of so-called hold separate orders. And that was the rule of the day. People would go forward with the merger, and then there would be this agreement, often in the form of an injunction or temporary restraining order of some sort, whereby you would allegedly hold the assets separate, and at the end of the case or at the end of a consent decree or whatever it might be, either they would be divested, or some of them would be divested, or they would be melded into the acquiring company.
So what kind of cases did you try while you were at Donovan Leisure, and do any particularly stand out?
I tried a lot of cases, really, at that time. I'm going to talk about the cases prior to the time I went back into the government, but I tried a couple of government cases against the government, that is, and tried a couple of civil damage cases, just to mention a couple of them. One was a merger case brought by the government in Charlotte, North Carolina. It was a merger between a little unknown bank by the name of Wachovia
Later became a big known bank.
Yeah, this is the early 70s, so much later became one of the biggest banks. But this was Wachovia. I'd never heard of it at the time. And they bought a company called American Credit Union. Both were based in Charlotte, North Carolina. And the government brought suit alleging a violation of Section 7 and moved for a preliminary injunction. And it was heard by a judge whose name now eludes me, but he was the same judge, Jim something. He was the same judge who had just recently ruled on desegregation in North Carolina and on busing. And a great guy.
He had the Charlotte school busing case.
Exactly.
Yeah.
And he was a real old Southerner, but he was an enlightened guy, and he suffered all kinds of public humiliation as a result of it because people really protested it. But he happened to be the guy who had this case, and we tried it against the government on a preliminary injunction. I remember vividly because Jim Withrow, who was the guy who had hired me and was my senior partner, was also on the case with me, and did some of it, but I had sort of the laboring oar. And at the close of the trial, which had probably taken place over 3 to 5 days, I don't recall how long, at the close of the trial, the judge said, okay, I'll hear argument. He heard argument, and he said, do you guys, pointing to the government and to us, want me to rule now, or do you want me to think some about it? And without asking, I don't know where I got the nerve, I leaped up, didn't ask Jim, which I should have done, and said, rule now. I don't know why or how I did that, but I did. He said, okay. He went back, and we sat there. It was like waiting for a jury to come in. And we sat there, and he came out, and I sat there, and you think the end of the story is going to be I won or lost. I didn't. He said, I can't do it. I need time. He eventually ruled for us.
Were you a partner yet at the time
I
you
was
made
a partner
this decision?
1 year. 1 year.
Gutsy move.
I wasn't sure I'd see 3 years. But so that was one. And then later I tried a case before a guy who I thought was the best district judge I was ever before, who is, well, he's now senior, but he is on the Third Circuit, a fellow named Lenny Garth. We brought a case, obviously in the other case against the government I was a defendant. This one we were plaintiffs, and we brought a case on behalf of a company called American Motor Inns, which was a franchisee of Holiday Inns. This is in the early 70s also. And American Motor Inns was actually the largest franchisee of Holiday Inns, but it itself was a public company. And it bought a parcel of land near the Newark Airport, which is obviously enlarged over time, but they knew it was going to enlarge. So they bought a plot of land and wanted to build a Holiday Inn. They applied to Holiday Inn to build an inn, and Holiday Inn determined that there was other inns within the area, other Holiday Inns within the area, and that it would in effect be cannibalizing their business. So they denied them the license, which would have been okay, except for one thing. They had in their contract, Holiday Inn did, in their franchise agreement, the provision that if you were a Holiday Inn franchisee, you could not be a franchisee of any other chain. So it effectively meant that the company was stuck with a parcel of land that was ideally suited for a motel. I suppose it could have been used for something else, but was designed for that purpose. And they couldn't develop it. So we sued Holiday Inn and claimed that two things. One, that the clause in the contract, which we call the non-Holiday Inn clause, was a violation of the antitrust laws. And secondly, that there was a conspiracy among the franchisees in the area to have Holiday Inn deny the application in the first instance. And in those days, what Holiday Inn used to do is they would solicit the views of the 3 franchisees near wherever the applicant was. And in this case, they solicited the views. The franchisees, to no one's surprise, came back and said, no, we don't want them. And why would they? And we said, wait a minute, that's a conspiracy. And we tried the case before Judge Garth in the District Court for New Jersey. And if I can just tell one funny story, and hopefully not in a way that really is too negative to the person involved, but we had tried this case, and Holiday Inns was represented by its regular counsel. And for whatever reason, on the eve of trial, Holiday Inns decided that they really should have more clout in their legal representation. And they got their Association of Franchisees, which is not uncommon. They have this association. They got the association to hire Milton Handler and the Case-Showler firm. And Milton Handler and the Case-Showler firm made a motion to intervene as a party claiming an interest. And we opposed the motion. Not a lot of great grounds to oppose the motion, but we did. And we ended up before Judge Garth, and Garth said, as I understand your opposition, it is only based on time that, this will delay the trial. But if I say the trial won't be delayed, then you can't possibly have any objection. And we were forced to say, I could possibly have one, but it's not going to be successful. And so he ordered us to trial, and we went to trial with Holiday Inn as a party, as another defendant. And once they came in, I amended our answer to allege a conspiracy between the Franchise Association and Holiday Inns. And we put on our case. We were the plaintiff. We put on our case, and we put in some not overwhelming evidence, minutes of some board meetings of the alleged conspiracy. At the close of the plaintiff's case, our case, the defendant and the Franchisee Association moved to dismiss. And we started the argument, and Milton Handler went through his argument, and counsel for Holiday Inns went through their argument. And at the end, he said, fine. And then he said, Mr. Litvack, you want to respond? And I responded with vigor. And he said, well, let me ask you a question. Are you really opposing this motion by the association? And I said, absolutely, Your Honor. There's a conspiracy, and we've proven it. And he said, well, hold on a minute. Mr. Handler, what happens if I deny the motion of Holiday Inns and grant your motion? You're out of here. Handler said, well, you can't do that. And the judge said, I can't? 1 minute. Mr. Litvack, do you really oppose this motion? Now, finally, the light goes off, and I said, no, Your Honor, I don't. And Handler said, I don't understand, Your Honor. The judge said, well, I'm granting your motion, Mr. Handler. I'm denying Holiday Inns. And Handler said, can I have that in an order for appeal purposes? And Judge Garth looked at him and said, appeal? Who? You won. He agreed. Who's going to appeal? And that was the end of that. In any event, the judge went on ultimately to find a conspiracy and to find the clause illegal under a rule of reason test. And the latter point was remanded by the Third Circuit in Arlen Adams and never tried again. We settled it after it came back because they had affirmed the conspiracy part.
Well, so they managed to convert what would have been a vertical decision into a horizontal
Absolutely.
Arrangement by consulting with franchisees.
Yeah, exactly. It was a fun case in any event.
So after these years in private practice, did there come a time when you went back into the government?
There did. In either 1978 or 1979, I got a telephone call one day from a guy who was a friend of mine in that we had opposed each other on several cases. We had never really been friends. We had been friendly opponents. And his name was Don Flexner. It still is, I think. And Don was then a Deputy Assistant Attorney General. And one of the deputies had left. I don't remember this. He called me to say that John Shenefield had asked him to call me. John was the Assistant Attorney General, to see whether I would be interested in becoming a Deputy Assistant Attorney General. And I said to Don, tell John that the only job I'd be interested in is his. And I thought I was being very funny, and that was the end of it, until months later when John Shenefield called and said, I'm going to be moving up to become Associate Attorney General and talking to people about the possibility of succeeding me, and I'd like to chat with you if you're interested. I said I was interested and came down and went from there and finally got the job.
Well, you've often told me that you think that's the best antitrust job in the world.
No, it's not the best antitrust job in the world. It's the best job in the world.
All right.
It is the best job in the world.
And why is that?
For loads of reasons. First of all, the division is my home. I mean, professionally, that's my home. I love the place. And there's a camaraderie that exists there and existed from the time I started in 1959 and exists in 2009 among the people there. That's number one. There's a professionalism and a camaraderie that's unique, I believe. Number two, it's the best job because you are dealing with great issues, with important issues that transcend, in many aspects, antitrust per se. They're policy issues. They're policy issues that affect our economy. There are policy issues that affect, in many cases, our defenses, our relations with other countries, a wide range. And I got the opportunity on some small level to deal with every one of those aspects during my tenure there. And I've had a lot of other jobs, as you know, and a lot of them were great, but none like that.
What did you do during the period that you were the AAG? What were the most significant things that you recall of that tenure?
Well, first of all, I came to the job with a certain bent. For right or for wrong, I did not feel, and I do not feel, and I don't say this to be falsely modest, that I was the intellect that a lot of my predecessors and successors were. And so I didn't bring, for instance, as Bill Baxter ultimately did, a whole range of great economic thinking. And I say great, whether it was great or not great, it was a range of economic thinking. What I brought, in my view, was skills as an antitrust lawyer. I was a practitioner.
And a trial lawyer.
And a trial lawyer. And that is what I thought I could best bring to the division. And so what I tried to do was I did a variety of things. First, I initiated regular meetings monthly with each of the section chiefs to go over every case, every matter, every investigation that they had. And we would do that regularly. I would do them at first thing in the morning from 8 to 10, and then from 6 to 8 at night. So I would set aside 4 hours a day to do that. I would do that regularly, and I'd stay on top of the cases so that I knew what was going on, and I could give whatever input I thought was helpful or useful. I also used to, I'm going to say teach, and that's probably not the right word, but hold a purely voluntary sessions at 7 in the morning. Whomever wanted to come in was free to come in. The only thing I did was I brought donuts, and that was the lure. And they would come in at 7 o'clock, and it was mostly, as you would imagine, the very young attorneys. And I would just talk about whatever they wanted as generally submitted to me before. And it was trial things. It was cross-examination. It was taking a deposition. It was document discovery. It was whatever, interrogatories. It could be anything. It could be preparing a witness. It could be cross-examination. In many cases, it was grand juries. And one of the things I found when I went in, and I think it's probably still true, unfortunately, is when I would read a grand jury transcript, for instance, and I don't think many assistant attorney generals read them, but I would. And I would read them, and the memo would say, A, B, C, D agreed to fix prices. And you'd go read the transcript, and the question would be, was there a meeting? The answer, yes. Who was there? A, B, C, D. What happened? They agreed. Okay. Then what happened next? And I used to have to go back and say, that's not evidence. You're not getting that in. Who said what? What happened? That's a conclusion. And
you can get away with it in a grand jury, but you'll never get away with it in a courtroom.
Well, that's the point. Sure. In a grand jury, you can get away with anything. But if you want to use that as evidence ultimately, and you want to say there was an agreement, you have no testimony to that effect. And what you're likely to find is when one of those witnesses takes the stand, they're going to say, oh, I really don't recall. And you'll say, oh, gee, Your Honor, I just want to tender that they agreed. And he's going to say, no. You got to give me the substance of what was said. So in any event, that's the kind of stuff.
What were the notable cases that you recall from that period when you were AAG?
Well, we brought a couple of merger cases, but probably the case that I'm best or worst known for was the Cuisinart case. One of the things I did, which in retrospect may or may not have been right, I'll talk about that in a minute, was say that vertical price fixing was illegal. It was illegal per se, and really should be treated no differently than horizontal price fixing. Now, I must say I didn't draw a distinction then, which I did in my own mind, which was setting maximum prices I didn't find as offensive as setting minimum prices.
Right. Although at the time they were both per se
They were
illegal.
both per se illegal. Yeah,
Right.
yeah. I mean, Albrecht had dealt with maximum prices, as you may recall, but not in a criminal context. But they were both criminal. And I was determined to, having enunciated that, I was determined to bring a case, and ultimately did bring a case, against Cuisinart's, the company, for vertical price fixing. We did not indict any individuals. We did indict the company, and it was resolved with a plea. That has received a lot of criticism, and certainly looking back, now that the Supreme Court has held that vertical price fixing is not per se illegal in the first place, looking back, it's a fair subject for criticism. The only thing I would say is that the people who criticized it, not getting into the Supreme Court about it, Bill Baxter used to argue, and I had great respect for Bill, but disagreed with most everything that he said and thought. But Bill Baxter used to say, you know, what's important is only interbrand competition, not intra-brand. And to this day, I don't understand why you can't have both. And so I'm old-fashioned on that score. And while I know that the case has plagued me in some ways, in some quarters, I'm not so sure it was so wrong. Once you start with the proposition that it is per se illegal, which it then was, I'm not so sure the case was wrong, and I'm not sure why you can't have intra-brand competition and why that isn't important in many
Well, and
cases.
at the time, Cuisinart had a pretty significant position with respect to the food processor.
Oh, totally.
business.
They were it. Yes.
There was
Oh,
no
yeah.
one else, because I
They were it.
remember buying my first Cuisinart about that time.
It was almost like Kleenex. You referred to the brand, became a generic. You know.
That's exactly right. Now, how had the division changed in the 20 years between your first two tenures?
It had grown a lot. I mean, it had grown a lot. I'll tell you one other thing, which it probably was true when I was there the first time, but as you can imagine, you wouldn't know this as a young fella. We in those days, and it used to annoy the Attorney General no end, we had our own budget directly from Congress. And so, you know, we had our own, I think our budget at that time was $49 million. Well, probably when I had come in, the budget was probably closer to 9 than 49, if that much. The division had grown a lot. A new economic era had come upon us to some extent. Obviously, things had changed in the 20-plus years. Deregulation was the order of the day. It had started under President Ford and continued under President Carter, and the division was a leader in the deregulation field. And a lot of what we did, a lot of what the division did, and Don Flexner headed up a lot of it, was in the deregulation, airlines, trucking, rail. So that was a lot of what went on.
So advocacy before the federal agencies that were responsible for those industries?
Yes.
And before Congress?
And before Congress, both. And that really, I don't think existed much, and if it did exist, I certainly wasn't privy to it, but I don't think it really existed. So that was a major change in focus. Also because there was a wide range now of field offices, and the field offices were much into the criminal cases. They did a lot of the criminal cases. And that was kind of a change, which has now changed the other way again. But a lot of it was run out in the fields, and we had a lot more field offices than they do today. So the division had grown and had matured and really had taken on a different role. Section 7 had changed. Hart-Scott-Rodino had changed the laws. There were now, toward the end of my tenure, there were more and more exemptions passed, too. I mean, another factor we had to deal with. But advocacy before Congress became a big part of the job.
And did that involve relationships with the White House in trying to determine what the administration's position would be, for example,
Yes.
on the issue of deregulating the airlines to allow greater competition?
Yes, there was always an effort, obviously, to come up with an administration position. OMB was charged with the responsibility for coordinating points of view. I'll tell you a slight story in that regard. There was a piece of it's a story which reflects on President Carter and kind of the kind of guy he was. We could meet over in EOB and talk about what position the administration should take. And there was this one particular time we met over there, and the issue was what were they called? VRAs, voluntary restraint actions, and this was directed toward Japan and automobiles at the time, because we were starting to see the influx of Japanese, mostly Japanese, but to some extent German, but mostly Japanese cars in this country. The Chrysler, Ford, and General Motors were obviously chagrined at the notion that the companies were selling cars here and wanted tariffs to, in effect, block them, but certainly raise the barrier for their coming in here. And we had to coordinate a government position. And I remember a meeting, and there was legislation being introduced, and there was a question of who was going to take what position. And as so often happened, you'd get over to the White House, and Stu Eisenstadt was then the president's domestic policy advisor. And we had a meeting, and I don't remember where all the parties were lined up, but for purpose of this conversation, I'll say the division I know was opposed to legislation dealing with this and felt that they should be allowed to come in and compete. The Commerce Department agreed with us. The Treasury Department agreed with us. The Department of State disagreed totally because they didn't want to aggravate or irritate the Japanese. The Defense Department disagreed. And so Stu ended up saying, well, I think what we should do is we should have an options paper for the president. And he wrote, or we actually wrote, he would frame the issue. And then each of us would write a paragraph describing why we thought we were right. And then there'd be two boxes. One, agree with state, agree with justice, and the president would check one of the boxes. And this was designed to minimize the president's time in having to go through so much. And we did our thing, I'll never forget it. And one of the issues was whether injunctive relief should be available. And we thought it should be, and others thought it shouldn't be. And I remember it came back from the president that he agreed with the others, not with justice. But he took the time to write that the reason he disagreed with us was he thought we were able to accomplish this without the need for formal injunctions. And he wrote this whole long thing, and I thought, isn't that amazing? He took the time as a non-lawyer to A, understand the issue, and B, write to explain, which he hardly had to do, to explain what his reasoning was. In any event, that was the kind of thing that would go on. And went on a lot. The good news was that it was very thoughtful. The bad news was probably the president spent too much time doing those things.
Doing those things. What role did the economists play at the division when you were back there?
Far less than they do today. I was not the economist's best friend, I'm afraid. I liked them. They didn't think I paid enough attention to them. They may still think so today, I don't know, about others, and not just me. The economic division was there. We had a head of the division who was a fellow named Bruce Owen, who you know, I'm sure.
Yep.
And they were very heavily involved in the major cases, like AT&T, which was one of the major cases you were asking about.
Which you inherited, as I recall.
I inherited but took it to trial.
Yes.
IBM, which I also inherited and didn't do anything with. And they, the economists, were very involved in those. They would have input to merger type issues, but they were by no means the deciding vote in any way. And they had little or nothing to do with any of the price-fixing cases. And they were much smaller. I mean, there was a relatively smaller group. So they thought that a lot of what we did, I mean, take, for instance, my vertical price fixing.
Sure, they were not enthusiastic about that.
To put it mildly, they thought it was totally nonsensical and a waste of time. So, as I say, I was not their hero.
Well, President Carter lost his bid for re-election, so you were back in the job market.
I was. He did. I used to say to people, oh, gee, we don't want you to go. And I'd say, they put it to a vote. and I'm gone. I stayed on for a while under the Reagan administration because they asked me to. Bill Smith asked me to stay for a while. One of the great mistakes. If I were to advise anyone, when an administration changes, go the day it changes. Don't stay on.
I think mostly they do that now.
Well, he asked me to stay because he didn't, Bill Baxter hadn't been selected, or if he had been selected, it hadn't been known. And he asked me to stay. And Bill Smith was always nice to me, and that was fine. It's just, you're yesterday's news.
Right. And
you're afraid to make, I was hesitant, I don't know about afraid, hesitant to make any decisions, mindful of the fact that a new group was coming in and they should make their own decisions, right or wrong. So, but I did stay a while. I then went back out into the job market, and after much consideration, because I was bit with Potomac fever and wanted to stay in Washington, But I had promised my wife at the time that if we did this, I would go back if she wanted to, and she did, and we did. And I went back to Donovan Leisure.
What was the major case you tried at Donovan Leisure during your return?
Probably the corrugated case was the major case that I tried. We tried that in Texas for 5 or 6 months before a jury down there. These were the opt-out cases. Steve Sussman had tried the class action case.
And won a record jury verdict on behalf of the plaintiffs, as I recall.
Record, yes, at that time. There were a number of large companies that opted out of the class. Pillsbury, for example, being one of them. There were a whole bunch of others. Anchor Glass was another. There were about 10 companies. And they brought the same basic suit that Steve had brought. Presumably with basically the same evidence. Same evidence, exactly the same evidence. They used the depositions from those cases, plus some more that they took. They used the same economist that
and
Steve
there was a
had
different
used.
Outcome, as I recall.
There was a different outcome. The jury found for the defense. And it was an interesting case because it was tried before, apart from the jury, before the same judge who had tried the criminal case. Remember, the government had tried the criminal case and lost.
Right.
Then the civil case was tried by Steve and won. And now we were trying the case. And the judge, a man by the name of John Singleton, I am convinced, was absolutely convinced that the defendants were guilty and thought it was a miscarriage that the government had lost, thought Steve was the greatest lawyer he'd ever met and had gotten the right result, and was, while judges are always disinterested and dispassionate, probably at bottom he pretty well thought we were going to lose and thought that probably would be the right outcome. But it didn't work that way. We got a jury verdict. It was a great trial. We felt really good about it. It was a lot of fun. It was 5 or 6 months of my life, but it was good.
In Texas.
In Texas, in Houston.
Now, at some point, you left the private practice of law and
did.
went into a company. Tell me about that trip.
That was a trip. I left the private practice. I had been representing Disney for a couple of years at that point. And in 1989-ish or so, Frank Wells, who was then the president, had asked me whether I would be interested at all in coming to Disney to be general counsel, and I had told him I would not be. And Frank was a guy who never took no for an answer, and he kept the conversation going on a periodic basis over time, asking me to come there. And for me, it was a hard decision because I lived all my life on the East Coast between Washington and New York. My family was here. I had practiced law for all those years. I had been between the government and private practice. I had never been in a company. Obviously, I had advised a lot of companies. And so it was a tough decision. And the move was no small part of it, quite obviously. But after much soul searching, I decided to do it. And I decided to do it probably for a variety of reasons, but among the reasons was the fact that if you are advising companies and you are in a private practice for years and get to know CEOs and get to know general counsels and you're advising them, you're always thinking you could do better. You're always thinking, gee, why didn't they ask me? I would have told them whatever. And so I thought to myself, well, you know, if you're so smart, why don't you go do it? Let's see how smart you really are. I found out I wasn't. And it was the challenge. And I had reached a point in my life where I felt, you know, I've done this. I need a new challenge. I've done the government. The only other thing I ever wanted to do was to become a district court judge. And that wasn't going to happen. And so I said, okay, I'll go do it. And off I went to, as they say, to Disneyland, except I went to California and not to Disneyland, but to Burbank.
Well, and Disney hasn't had at the time a very diverse portfolio of products. It isn't just Disney and Disneyland and cartoons.
Huge, huge. I mean, we had the studio, which did everything from producing full-length motion picture films to videos to making television product. We had, obviously, the theme parks, which were Disneyland and Walt Disney World and Tokyo Disney and ultimately Disneyland Paris and more. We had consumer products. I mean, we sell more products. I have to stop saying we. I haven't been there. But Disney sells more products than you can possibly imagine with its name on it.
And its own stores.
And its own stores. And its own stores. So it was a very, very diverse business, and one which I was interested in being in because it was so diverse.
Didn't they even own a baseball team?
We did own a baseball team eventually, and sold a baseball team eventually, and we owned a hockey team.
That's right, the
both.
Ducks.
The Ducks, the Mighty Ducks of Anaheim. Mighty Ducks of Anaheim. And the Angels. So we had both clubs. We bought ABC while I was there, which was ESPN, and part of Lifetime, part of A&E, Biography Channel, History Channel, all those things were part of what we ended up. We also had a music company. We did music both for kids, and ultimately we tried to do music on a more adult level.
At some point, did you move into management?
I did. I moved into management. Frank Wells died in 1994 in a helicopter crash, which was obviously tragic and unexpected. And with that, I took over a lot of what he did, and I moved more into management. Legal continued to report to me, but eventually I hired a new general counsel, and he in turn reported to me. But I had a much broader portfolio, really. Virtually all the businesses reported to me in one way or another.
After your period at Disney, you went back to the private practice of law.
I did, yeah.
And tried antitrust cases and other kinds of cases. But at some point not long ago, you did your third stint.
My third stint.
At the Antitrust Division. Tell us how that happened.
It was my third stint. I kept saying I'm going to be the oldest guy here. I keep doing this, but happily Bernie Hollander was still there, so I wasn't the oldest guy. I was out of the blue. These things have always happened surreptitiously to me. Out of the blue, I got a telephone call. I was on vacation in the Galapagos, where you can't get telephone calls, and I didn't get a telephone call. But when I got to a place where I could call the office, which I did, just checking in, my secretary told me that Deb Garza, who was then a Deputy Assistant Attorney General, had called and had said she'd like to talk to me, and it was fairly time urgent. Could I please get to her? So I did call Deb, and when I got, again, to another land place, and she told me that they had a matter. She did not tell me what the matter was, did not tell me who the people were, the companies involved, but where they thought they could use some outside assistance. And would I, the only question at that point is, would I be interested in the possibility of coming back to the division on some basis to do something? And I said, sure, without knowing more, I would be interested. And she told me that it was a matter which didn't report to her per se, it reported to David Meyer, but that what she'd like to do is set up a conversation between David Meyer, among David, Tom Barnett, who was then the Assistant Attorney General, and myself. I did. I learned that it was to look into the Google-Yahoo matter agreement, which had been forged sometime in June, and the division was looking at it in a very tight time frame. The parties had given the division 100 days in which to reach a determination as to whether they wished to challenge it or not. It's important to remember this was not a Hart-Scott-Rodino filing, and therefore there was no time frame except whatever the parties wanted to do. I mean, the parties could have gone ahead and done the deal without waiting for the division at all, but they chose not to do that and probably decided as a practical matter that it was going to get enough scrutiny, which it did, both from Congress and the government, that it made sense to formalize a procedure and be cooperative. And they were. And after talking with Tom and David and Deb to a lesser extent, I agreed to come back to the division to basically head up what would be a challenge to the agreement if the division were to decide to challenge it. And one of the things I was very interested in, or anxious to make certain of, is that I would be involved in the decision or in recommendation of whether or not to bring the case in the first place. In other words, the idea was if a case were brought, I would try it. Well, I didn't want to have to try a case I hadn't thought should have been brought in the first place, or hadn't been shaped the way I thought it should have been shaped in terms of both the evidence and the claims. And Tom and David were perfectly content with that, and so I had to leave, unfortunately, Hogan and Hartson. That was one of the other conditions that they imposed. They were so conscious and concerned about conflicts, so I left Hogan and went for my third stint, which then ended, and I came back to Hogan.
So you were at the division that time in about 60 days, is my recollection?
That's about right. Yeah, could have been a little more, but give or take a couple of days, I'd say that's right.
And at the end of your stint at the division, Tom announced an intention to challenge the transaction if
Correct.
Google and Yahoo proceeded.
Correct.
And they abandoned the transaction. Google abandoned the transaction, and you came back to the private practice.
And that was the end of it, yes. And that was the end of it. We were prepared to challenge it, as Tom announced, and they weren't prepared to defend it.
It would
or
have
at least
been
Google
a
wasn't.
great case to try.
I would have loved. I mean, I've said that before. I would have loved it. I don't think there's any trial lawyer who's prepared a case who wouldn't love then to try it. So I'm no different. But it didn't work out.
And in private practice today, you have a litigation practice, and you represent companies involved in cartel investigations. And how have the cartel investigations changed, especially starting from your original stint in the government to the kinds of cases that you're involved in today on the other side of the fence?
Markedly. It's probably, in some ways, the biggest single change that has taken place. And just to give you a couple of ideas. One is the cartel cases today are virtually, not all, but virtually all international. That didn't exist. Didn't exist 50 years ago. Didn't exist 20 some odd years ago. When I was Assistant Attorney General, the biggest price-fixing cases we had were the asphalt people.
Exactly. Road building.
Road building. That was a big deal. I mean, and we were indicting them left and right. And I remember, when we would finally get jail terms. You got to remember, the Sherman Act has been amended several times over the years. So, like when I was first there, a Sherman Act violation was 1 year in jail. No one got 1 year in jail. No one got any time. Everyone got suspended sentences or nothing, and individuals weren't indicted. By the time I came back as Assistant Attorney General, we were indicting individuals, and we were getting jail terms. Now, nothing compared to what there is now. And we were getting fines. Nothing compared to what there is now. So what has really happened is three things. One, the division has greatly expanded its cartel capacity and capabilities. It has gone international. The laws have changed so that the penalties have greatly increased, both in terms of jail time and in terms of potential fines. And the division is getting those fines and getting those jail sentences either by plea, well, mostly by plea. I mean, the truth is, at the end of the day, the government really isn't trying that many of these cases. Now, that could be because the individuals and the companies don't want to, are incapable, the risks are too great. All of those come to play. The evidence is too strong. All those things come to play. But the fact is, you look at the government. When I was just there recently, they were telling me they have something like $2 billion in fines last year.
It's stunning.
That's stunning. I would say there wasn't $2 billion in fines in total for the first 100 years of the Sherman Act.
I think that's probably right.
I don't know that, but I would guess it.
Well, and and then the leniency policy. Unfortunately, we have about
really
2 minutes,
changed.
so we've got to wrap it up. But the leniency policy is a dramatic change, and I think that's really changed the whole paradigm.
It has. Just one quick thing within the time. That policy basically started under John Shennefield and continued under me. Nowhere near as elaborate or as effective as it is today. I don't want to claim credit, but the concept was one John had. And one of the concerns at that point was, gee, how are you going to get anybody to come in? Judges weren't really sending people to jail. You still have treble damage liability, so why is anyone going to come in and tell you too much? And they have dealt with that. They've dealt with both, and even including the treble damage liability in some cases.
Well, thank you, Sandy. This has been a real pleasure.
Well, thank you, Jan. I've enjoyed it. Thanks very much.